Today we get to talk about some more implied covenants, so implied covenants to develop, explore further, etc. So there are a lot of different implied covenants to drill in one way or another. We talked about the implied covenant to test, to drill and explore for oil in the initial stages of the primary term. We'll talk about the implied covenant to develop, and we'll talk about the implied covenant to explore. So that implied covenant to test is the one that we talked about before. So you can see it described in more detail on page 412. It just says the lessee, the oil and gas company, has to test the lease premises within a reasonable time. Otherwise, they'll lose the lease. Nowadays, that's disclaimed by the delay rental clause. The delay rental clause says, let us keep it for the whole primary term. Every year, we'll give a little bit of money in return for not drilling, and a modern, well-drafted, paid-up lease just says, hey, we've given you all the money up front, gave you basically, just imagine we gave you all the delay rentals up front, we get to keep it throughout the primary term because it's a paid-up lease. So that implied covenant to test isn't a big issue in modern leases that use either a paid-up lease or delay rentals. Now, the covenant to reasonably develop, this is a little more controversial. The idea is once the lease is held by production, the lessee would still have to reasonably and prudently develop it, even if one well would eventually drain the whole tract. So why would you need to keep drilling wells if one well would drain the whole tract? Well, maybe the idea is, look, as the landowner, I want more money today. And so, yeah, from the oil and gas company's perspective, perfect to have a single well, never have to pay for it to drill again, drains the whole thing. From my perspective, I'd like my money sooner, drill a couple wells. To prove a violation, the lessee would have to prove that additional wells could be drilled profitably. So at least oil and gas company would get paid back for its well, plus some money, and needs to show also that the lessee has acted in some way unreasonably, imprudently, or untimely in failing to drill. Now, here's an example of that covenant in action, the Superior versus Devon case. This is from the 8th Circuit, Nebraska, 1979. So facts are a little bit more complicated. Let's put it like this. The lessee had drilled a producing well in the 1950s and unitized, it's often a last stage of production, in 1961. Still producing a little oil. The lessors want further development, so they give a top lease. What's a top lease? Well, a top lease is a lease that goes into effect when the bottom lease, the underlying lease, expires. So they gave a top lease to Christensen, and Christensen says, I think this old lease has expired, goes on and drills a producing well in 1977. Okay, so this is decades after the initial lease and decades since there's been a lot of production on this area. Trial court says that's okay because the lessee breached its implied covenant to develop, therefore the lease was just canceled. Regardless of what the lessee did, it had been canceled automatically at the time the top lease was given. The appellate court here reverses, and they say you can't just give a top lease and say the lease is expired without first going to the lessee and saying, hey, you need to further develop this property. There are profitable wells you can drill. I mean, obviously one was drilled, so you should go out there and do it yourself. So there has to be notice and an opportunity for the lessee or the gas company to address this problem. The dissent disagrees, and it says, no, the lessees here, the oil and gas company, not entitled to notice. They should have known that it was long past time to drill another well, and they should have known they were not being prudent. They were basically just speculating and thinking they'd hold on to this lease and maybe decades in the future they would drill on it. Now notice that presents the same kind of problems of gray areas as we had with paying quantities, whether a reasonably prudent operator would continue to develop the land. Because the question is, just like we said, it's kind of a hard line between, or it's difficult to draw a line between speculation and profit. Same thing here. I mean, if the oil and gas company had a plan that it was going to develop it in the future, how do we say that really isn't quick enough? And isn't it a rational thing that a prudent operator does is wait for potentially better opportunities, better information about where there may be more oil and gas on this leased property. Okay, so some things to take out of this case. One is, when are notice, demand, and an opportunity to cure required? Obviously, the appellate court required it here, but I think the reality is that's something you definitely want to give to the operator. If you're a lessor, landowner, and you think your lessee, oil and gas company, hasn't developed the lease enough, you need to let them know. So a couple reasons. One is, when you're seeking cancellation, you definitely need it, as we saw in this 8th Circuit case. But even if all you want is damages, and you say, well, you should have drilled earlier, the problem is, when do those damages start? If you should have had more oil produced on your land and thus receive more royalties, when should, in this case, the oil and gas company have drilled? Well, the problem is you don't have a real date to attach that to unless you have a date that you sent them notice that they should have been drilling a new well. So as a practical matter, if you want damages, give notice. If you want cancellation, give notice. If you think the oil and gas company on your land isn't doing enough, let them know. Okay. When can a lease be unconditionally canceled? Rarely. You see the dissent here and the trial court, saying, well, maybe this was so egregious, leaving this land without any development, that it should be unconditionally canceled. That's very rare, unless there's some kind of bad action, bad faith of the oil and gas company. Usually the best that you're going to get is a conditional cancellation that says, okay, they need to drill a well really soon here, otherwise the lease will be canceled going forward. So conditional cancellation is more common. Damages for failure to develop. Okay, one is lost royalty. So lost royalty would be royalty that the lessor would have received if the lessee had reasonably and prudently developed. So again, you have some date of notice, you can start it from then and say, I should have drilled then, I should have got 5 more years of royalty, here's the royalty I would have received. Another way you could do this is say lost interest. So if they should have drilled 5 years ago and they're drilling now, in theory, I should start getting a royalty. And I should end up getting all the royalty I would have got otherwise, except I lost interest because I could have had that money earlier and it would have been accruing interest. Note that if you use the lost royalty approach, you often have to come up with future credit, because basically you're saying, well, they should have been producing hundreds of barrels of oil every year, every month for me from this property. And the oil and gas company says, well, okay, yeah, we didn't produce it for you then, we paid you the damages, but now we're making up for that. So we should have a set-off. We should get credit for that production as it comes in to pay off those damages that we've already paid you. So future credit is often used with lost royalty damages. All right, more controversial covenant, the covenant to explore further. So this is a covenant that says, look, even if the lease is held by production, so you got a producing well, and even if you don't know of any other oil that could be developed, right? So we can't necessarily use that covenant to further develop. The lessee still must reasonably explore for more possible reserves. You could think about this maybe as an analogy with the covenant to test. Remember that said, you know what? You shouldn't just leave it for the whole primary term. Start drilling, start looking for oil. Covenant to explore further says, yeah, even if it's held by production, you should still drill some wells, or at least you do some exploration to look for more reserves. So the Williams view is that that covenant is part of the development covenant, as it's explained in your book. And so the lessor must prove the same elements, including reasonable profit. Now, so that's the view that's taken in Texas and Oklahoma. By the way, this is Judge Stephen Williams, oil and gas scholar, went on to be a DC Circuit judge, just died this year. He was a professor at SMU for a couple of years as well. So Judge Williams says, look, that covenant to explore further is part of the development covenant. So just like with further development, the lessor has to show that it would be profitable. Now let me ask you this question. How, if we don't know that there's oil and gas yet, how can you prove that it would be profitable to explore for it? Very difficult, often impossible. So that's why we say this covenant to explore further doesn't have a lot of purchase in most states, Texas and Oklahoma, that follow that Williams view. Now the Myers view is that the lessor must only show that the lessee should have tested the area rather than just holding it for speculation. Because Myers says, basically, if you have a lease that's held by production and you're not doing anything else with it, you're holding onto that whole property. What for? Well, it's a benefit to you for speculation. So the Myers view is that's enough. You don't have to show that it would have been profitable. Most exploration is not profitable. It's just the ones that hit that pay for the rest. And so that should be enough. As you can see, that's not a established view really anywhere. So the covenant to explore further is still not necessarily your number one go-to if you're looking to sue your oil and gas company if you're a lessor. All right. Now, every oil and gas company does have an implied duty as part of an implied covenant of the lease for diligent and proper operation. That just means they have to act as a reasonably prudent operator in the circumstances. It can't be negligent. So you have the case Baldwin versus Kubitz in your book, page 428. In that case, you had really bad violations of local health, safety, environment rules, zoning rules. And so if your operator starts violating those rules, and often that will mean that production is going to be shut down, which means you don't get a royalty, they will be liable for that. So they have to do everything properly in terms of complying with local rules and with local industry custom and practices. They have to get zoning variances. They won't be able to receive, and you saw this in this case as well, force majeure if the lessee caused the problem and didn't try to overcome it. So we talked about that in force majeure. You can't necessarily rely on force majeure if the government stopped you because you were doing something wrong. In that case, Kubitz also violated an express drilling obligation in the lease to keep drilling. There's often common claims for violation of the covenant for diligent and proper operation if you have property damage, antiquated technology, failure to seek some kind of action from the government that would have allowed you to go farther. So diligent and proper operation covenant basically covers a lot of mistakes, negligence, things that a company did that a well-run oil and gas company would not do.